Texas Rule of Evidence 501. Let's take a look. Hey everybody, Brian Foley here, your favorite Conroe, Woodlands, and Houston criminal defense attorney. We're going to talk about Texas Rule of Evidence 501. It is about privileges in general, and it says unless a constitution, a statute, or these or other rules prescribed under the statutory authority provide otherwise, no person has a privilege to refuse to be a witness, refuse to disclose any matter, or refuse to produce any object or writing, or prevent another from being a witness, things like that. So the rule of 501 is really a rule saying you can't use a privilege unless we say the privilege is specifically recognized. So when we look at the rest of the 500 series, those videos will discuss exactly what those privileges are, but here's a preview for you. We've got attorney-client privilege, probably the most sacredly protected privilege by other attorneys, right? The spousal privilege, which has some ins and outs to it, says that your spouse can't be forced to testify against you. Notably, that does not apply in a family violence case. They can be forced to testify against you in a case where you're alleged to have hurt them or a member of your family. Then we've got the clergy privilege for, when you go do confession to the priest, they have a privilege to not tell what's been confessed. The Fifth Amendment privilege, or the criminal law case privilege, it means you don't have to be a witness against yourself. They can't force you to testify against yourself. There's a political vote privilege, meaning you don't ever have to disclose who you voted for in the last election. The trade secrets privilege, so Coca-Cola doesn't have to give their secret formula recipe away during a lawsuit related to that. And then the doctor-patient privilege, you have to keep your personal health information confidential. One thing to know about privileges is there is no family or parent-child privilege. So if your child commits a crime, you can't, claim a privilege. If your spouse does, privilege all day. But in Port versus Heard from the Fifth Circuit, they determined there is no family or parent-child privilege. So what do you have to do in order to assert one of these privileges? It's not a whole lot. You basically have to put some information showing that the privilege is legitimate and you want to assert it. So if you're trying to assert a privilege, only a minimal showing of evidence is required by the party which wishes to assert that privilege, and the judge will make what's called an in-camera determination or review of the materials claimed to be privileged, and the opposing party may rebut that with evidence of their own, but the determination of the trial judge is going to stand, and it's going to be based on an abuse of discretion standard. Most of these rules of evidence are all going to be based on an abuse of discretion standard on appeal. One thing, if you didn't catch that earlier, the in-camera hearing, it's not like the judge has a camera, he's going to take pictures of it. It means he's going to go back to his office on his own and look at the materials without showing them to opposing party and determine if they need to be shown. And that is Texas Rule of Evidence 501. Thanks for watching. Don't forget to like and subscribe. Share with your friends, anyone who's a lawyer who might find this interesting, anyone at all. If you have an idea for a video, comment below. Make sure to click the bell for notifications, all that good stuff, and we'll see you next time.